as a shareholders. It has recognized all of my rights as a shareholders. The depositor is giving me all the corporate benefits. I am having voting rights, but my right to exit has not been taken into consideration, and there is no reason provided why out of all the 4 independent valuation report, only their report has been taken into consideration, when it is very probable that in that report there must be quid pro quo. Your Lordship, all this, if there is a suggestion that these things may happen, the only remedy is SEBI to interfere and make a transparent process. That is the humble submission of this council, Your Lordship. That this transparent, we are not contesting the price anymore, we are contesting the process. The council cannot substitute the technical knowledge of SEBI. But the council, what their council submitting is the process should be fair. That is the only submission, Your Lordship.
Yes, let me try to clarify what my learned brother was trying to ask. The refusal under the Civil Procedure Code, the refusal to pass an interim order is also appealable.
Indeed, Your Lordship.
All right. Now suppose you move an application before the court just gives directions.
Indeed, Your Lordship.
Affidavit in opposition or written objection by so-and-so, rejoinder by so-and-so, list the matter after so-and-so. Nothing is said about the interim order.
Indeed, Your Lordship.
Now an appeal does die, treating that as a refusal to pass an interim order. There is no doubt about that. But what my learned brother is asking, whether that letter can be treated as an order to that effect.
Indeed, Your Lordship, it will be treated.
You just make your submission pinpointed to that in 1 minute.
If your counsel have understood the question correctly, why that letter will be considered as an order, that is the concern of the bench, Your Lordship.
Yes, that's right. Your answer is, in short, that letter is to be considered as an
Order.
Refusing to pass an order in your application. Right?
Indeed, Your Lordship. The council seeks permission to proceed with the prayer. I'll just complete the prayer in 30 seconds and leave, Your Lordship.
You have to read the prayer.
No, Your Lordship, the council has come all the way for the prayer, Your Lordship.
Yeah, that's right. No, you did exceedingly well. In fact, more than a seasoned lawyer.
Your Lordship.
More than a seasoned lawyer.
My pleasure, Your Lordship. It is my pleasure. The council seeks permission to proceed with the prayer. Wherefore, in the lights of the facts of the case, issues raised, arguments advanced, and authorities cited, the counsel of the appellant humbly pray before this honorable court to adjudicate as it may graciously please to issue an appropriate order or direction. Firstly, to declare that the appeal is maintainable before the honorable tribunal and the appellant is a shareholder under the SAST regulation. Secondly, to declare that the valuation report is mandatory for the inspection. Thirdly, to direct SEBI for appointing an independent valuer. And fourthly, to direct the acquirer and the manager to the offer for revising the offer price, Your Lordship. And grant any other relief that the honorable court may deem appropriate in the interest of justice, equity, and good conscience, all of which are most humbly and respectfully submitted before this honorable court. This, the counsel for the appellant, shall duty bound forever pray. It was an honor to plead before the bench, Your Lordship. Thank you so much for your time.
Good afternoon to the honorable bench. If it may please the council. A very good afternoon to the honorable bench. If it may please, the council seeks the permission to address the bench as Your Lordship. Much obliged, Your Lordship. The council is appearing before the Honorable Supreme Court of Konark in the matter of Aryan Limited versus Securities Commission of Konark on the behalf of the respondent under Section 15Z of the Securities Commission Act 1992. Your Lordships, there are 4 issues involved in the present case. The council will be dealing with the first 2 issues and would be speaking for 29 minutes, and my co-counsel will be dealing with the 3rd and the 4th issue and would be speaking for 28 minutes. The council seeks the permission to proceed with the statement of facts. Much obliged, Your Lordship. Aryan Limited and creditor entered into a debenture trust deed by issuing the non-convertible debentures. Further, Aryan pledged the shares of the target company to the creditor. However, because of some default committed by the Aryan Limited, the shares were invoked by the creditor and transferred to the debenture trustee acting on behalf of the creditor. The debenture trustee continued to hold pledge over the 10% of the shares. Further, the shares of the target company were sold to the acquirer, and the acquirer further, through an open offer, sold the shares at rupees 50 per share. This undervaluation of shares has been contended by Aryan Limited as it will harm the public shareholders and has further asked the Securities Commission to conduct an inquiry. Aggrieved by the unsatisfactory responses received by the Securities Commission, Aryan has filed an appeal before the Securities Appellate Tribunal. However, aggrieved by the order of the Securities Appellate Tribunal, Aryan Limited has now filed an appeal before the Honorable Supreme Court of Konark under Section 15Z of the Securities Commission Act 1992. The Council seeks the permission to proceed with the arguments. Much obliged, Your Lordship. Your Lordship, the first issue deals with the maintainability of the appeal, which the Council will be dealing under two limbs. Proceeding with the first limb, Your Lordship, on careful perusal of Section 15T of the Securities Commission Act, it is very clear that an appeal can only be preferred against an order. The term order has not been defined anywhere in the Securities Commission Act or the SAST Regulations 2011. Your Lordship, there has to be an order to start with, and then comes the impact of the order on the shareholders and the investors. Your Lordship, in the present scenario, there is no order to start in the very first place. As Your Lordship, if you may refer to page 3 of the moot proposition, para 9, first line. Your Lordship, it has been mentioned over there that the Securities Commission reverted to the representation letters of the Aryan on 21st January by forwarding only a copy of the responses of the creditor, manager to the offer and the acquirer. Further, Your Lordship, on page 4, para 11, the manager to the offer, via its letter dated 18 February, informed the stock exchanges that it would only be forwarding the letter of offer to all the shareholders. Your Lordship, it is submitted by the Council that it is merely a forwarding copy and it cannot be treated as a final order in any sense. As it has been held in the case of Suman Motors versus the Securities and Exchange Board of India. Your Lordship, if you may refer to compendium, the compendium for the respondent, page 15 of the compendium. Your Lordships, if we are on the same page. Your Lordship, on page 15 of the compendium, in the Suman Motors Limited case, it was the case dealt with whether what should be treated as an appealable order, and it was clearly stated, as it has been highlighted in the compendium, that the mere expression of opinion or a piece of advice or comments by the Securities Commission on the draft letter of offer cannot be treated as a final order in any sense. Your Lordship, in the present case also, the Securities Commission has merely passed comments by forwarding a copy of the letter on the draft letter of offer for the proposed acquisition of 33% of the shares. Your Lordship, further, as per Regulation 18, Sub-Regulation 1 and Regulation 18, Sub-Regulation 5 of the SAST 2011, it has been mentioned that the board has the discretion to revise the offer price as accordance to the mandate. The board can certainly revise the offer price as it has been given under the SAST 2011 regulations. Your Lordship, pertaining to the said regulations and the case cited by the Council, which is the Suman Motors Limited versus the SEBI, the communication letter dated 21 January 2022 cannot be treated as a final order in any sense, as it was merely expressing comments on the draft letter of offer. Further, Your Lordship, the word draft in itself,
You are repeating it's not a final order. Is that interim order?
certainly no, Your Lordship, it is not an interim or procedural order. It is merely a direction, it is merely a forwarding copy.
Using
of
the word not a final order,
Your Lordship, it is not, it shall not be treated as it has been contended by the Aryan Limited, that it is a final order. It should not be treated as a final order, as it was merely a forwarding letter.
not an order itself.
It should not be treated as an order in the
Okay.
very first place. However, it is not it should not be treated as any sort of order in the very first place, as it was merely a letter communicating the comments on the draft letter of offer price. Your Lordship, the term draft letter in itself explicitly states that it is not something which can conclusively determine the right of the parties. It is something which is open to revision, it is something which is open to revision and amendments. Your Lordship, pertaining to the same as given under the SAST regulations, the Securities Commission, according to page 3, para 9 of the moot proposition, amended the past certain comments on the proposed offer price, and not something which can conclusively determine the rights of the appellant. Your Lordship, further, if I may proceed with the second limb of the first issue.
The form of an order or an application or any letter or any communication on which an order can be passed, mentioned in the Act or regulations.
Certainly not, Your Lordship. There is no explicit definition of the term.
To the section providing for appeal.
Yes, Your Lordship.
The provision to appeal to the appellate tribunal.
Your Lordship, according to section 15T, by an order of the securities appellate, it provides that an appeal to the SAT is available when any person is aggrieved by an order of the board made. However, Your Lordship, in the
An order, it does not mention final order, interim order, nothing of the kind.
certainly not, Your Lordship. This, as mentioned in 15T, sub-regulation A, this term order cannot be interpreted as a final order in any sense. It can merely be interpreted as an procedural direction, which the Securities Commission in the present case has passed in accordance with the communication letter dated 21 January 2022. Your Lordship, if I may proceed. Much obliged, Your Lordship. Further, Your Lordship, SEBI, being a regulatory body, has applied its mind, and being a fact-finding mechanism, has provided with all the valuation reports as stated in page 3 of the moot proposition, para 9, fifth line from the last, wherein it is stated that the valuation reports have been set out in detail, and all the relevant methodology has been employed by the Securities Commission to ascertain at a fair valuation price. Your Lordship, further, qualitative factors and all the dynamics of growth potentials have also been taken into consideration by the respondent while ascertaining the fair valuation price. With regards to the same, Your Lordship, SEBI, being a fact-finding mechanism and a regulatory body, has certainly complied with all the requirements of the SAST 2000 regulations and the Securities Commission Act 1992, thereby making this only a mere procedural direction and not a final order in any case. Your Lordship, if I may proceed with the second issue. Certainly, Your Lordship. Your Lordship, the second issue deals whether Aryan, having pledged their shares, do qualify as shareholders. Your Lordship, it is humbly submitted by the counsel for the respondent that Aryan do not qualify as shareholders, as in the very first place, the shares have been pledged by as Aryan Limited has no shares to offer in the very first place, as the shares have been pledged to the debenture trustee acting on behalf of the creditor. Your Lordship, if you may refer to page 1, para 2 of the moot proposition, it has been mentioned that on 3rd April 2019, under a share pledge agreement entered with the debenture trustee, Aryan pledged the 3.3 lakh shares of the target company held by Aryan to secure the NCDs. Your Lordship, this in itself states that the shares have been pledged, and once the shares have been pledged to the pledgee becomes the registered and the beneficial owner until the amount has been paid by the pledger. Your Lordship, according to section 173 of the Indian contract.
Do they cease to be shareholders after the pledging?
Your Lordships, in the present scenario, the appellant certainly has a right over the 10% of the shares, as the pledge hasn't been invoked by the debenture trustee.
They want a right of redemption?
Your Lordship, the right of redemption on the 23% of the share extinguishes once the shares have been pledged. However, the right on the 10% of the shares of the Aryan Limited do vest with the pledger, as the shares haven't been invoked. However, the counsel for the respondent is claiming on the 23% of the shares that on which the right of redemption cannot be executed. Your Lordship, according to section 173 of the Indian Contract Act, a reasonable notice has to be given by the pledgee to the pledger. Your Lordship, if you may refer to page 1 of the moot proposition, para 4. Your Lordship, the debenture trustee on behalf of the creditor on 30th October 2020 communicated to the appellant that the NCD facility has been accelerated and is immediately due on account of the default committed by the appellant. Secondly, Your Lordship, on 30th October 2020, the respondent very well stated the intention by giving a reasonable notice that the shares of the target company of the appellant will be transferred to the debenture trustee. Your Lordship, this reasonable notice has been given, and all the requirements under section 173 of the Indian Contract Act has been complied with, thus giving the appellant a reasonable time to redeem the pledged shares. However, the appellant in the present case hasn't redeemed the pledged shares, and therefore, according to the case of Reliance Media Financial Works Limited, Aryan do not qualify as shareholders, as Aryan do not have the shares to offer in the very first place. Your Lordship, if I may proceed with the second limb. Your Lordship, further, the respondent has... Certainly, Your Lordship.
173 of the Contract Act, the second section.
Yes, Your Lordship.
The redemption part, please read that phrase.
Your Lordship, the section 176 of Indian Contract Act.
Yes.
Certainly, Your Lordship, according to 176 of the Indian Contract.
The right to redemption remains till the sale takes place.
Certainly, Your Lordship.
So here your sale has not taken place. There is only an invitation to sale or offer to sell.
Your Lordship, in my second submission,
So once the sale has taken place, somebody else takes over the shares, gone.
Certainly, Your Lordship.
There is a transfer.
Certainly, Your
Okay.
Lordship.
Now, till that transfer becomes effective or final, the ownership remains, both legal and beneficial.
Certainly, Your Lordship, the ownership of the 10% of the shares still vests with the pledger, and the respondent is only contending on the 23% of the shares which haven't been, as the pledge hasn't been, as the pledge has been invoked on the 23% of the shares.
Invoked but not sold up to now.
Certainly, Your Lordship, if I may make my second submission with regards to the same. Your Lordship, in my second limb, the council humbly submits that a robust commitment by the Securities Commission has been given to a third party that the shares will be that the respondent will be selling the shares to a third party through a share purchase agreement. Your Lordship, in the present case, as stated, the respondent has certainly made a robust commitment to sell the shares of the appellant to the third party, and now the respondent cannot go back to the promise. And with regards to the same, Your Lordship, the respondent, as the respondent has made the final commitment, the constructive or actual sale can be interpreted from the same as the formal understanding between the third party and the respondent has been executed in the present case. Your Lordship, with regards to the same, as the right to sale has been executed by the Securities Commission through a share purchase agreement to the third party, the right of redemption of the appellant extinguishes in the present case. Further, Your Lordship, according to Section 173 of the Indian Contract Act, Your Lordship, according to Section 173 of the Indian Contract Act, the pawnee has the right to retain the goods until the full amount is paid by the appellant. Your Lordship, in the present scenario, the appellant has committed a default, and with regards to the same, has failed to pay the amount to the Securities Commission. With regards to the same, Your Lordship, the Securities Commission herein becomes a registered and a beneficial owner through the share purchase agreement entered on the 3rd of April 2019. Your Lordship, if Your Lordships are convinced with the present submissions, may I call my co-counsel for dealing with the rest of the issues?
According to your argument, the right to redemption does not remain. The sale has taken place.
Certainly, Your
Thereby,
Lordship.
the pledger loses his ownership over the shares. Then nothing remains for SEBI to do. It's a closed case.
Your Lordship, the Securities Commission is claiming on the 23% of the shares. Certainly, the right of redemption rests with the pledger on the 10% of the shares. And the appellant is the owner of the 10% of the shares in the
They are
present
not
case.
challenging 10%, 23%. They are challenging the 33% sale
Certainly, Your Lordship. However, the council
at an
submits.
undervalue.
Certainly, Your Lordship.
50 versus 150.
Your Lordship, if you may refer to, Your Lordship, as stated by the,
That is the issue involved. Whole 33%.
certainly Your Lordship. However, Your Lordship, if you may refer to page 1, para 3 of the moot proposition,
And under those regulations which you showed us, 3, 4, 5, 6 SEBI regulations, if it is more than 25%, then SEBI has a role to play in regulating the sale.
certainly Your Lordship.
If the bulk is, if it is a bulk of 25% and more, then SEBI can regulate the sale and also can adjudicate as to whether the valuation has been properly made, etc., etc. Not short of that.
Certainly, Your Lordship. However, because of the default and the non-payment of the fees, the Securities Commission herein becomes the registered and the beneficial owner on the 3rd of April 2019, as the appellant has failed to repay the amount. And and Your Lordship, there are two concepts which relates to the general property rights and the special property rights. And with regards to the same, the debenture trustee acting on behalf of the creditor here has the special property rights in the property, which states that the Securities Commission can sell the shares to the third party under the special property rights given under the section 173 of the Indian Contract Act. Further, Your Lordship, if you may refer to page 1 of the moot proposition. Your Lordship, on para 3, the last line, wherein the appellant is claiming that the per share, the last line, the proposed IPO had been priced at USD 55 million. However, the material subsidiary withdrew the IPO at the last moment due to the market uncertainties. Your Lordship, in the present case, as the appellant is claiming that the per share price has to be rupees 150. However, it cannot be conclusively ascertained that the price can be rupees 150 since the IPO was withdrawn. Your Lordship, it is still unclear unclear as to the reasons of why the IPO was withdrawn. Your Lordship, there could be n number of reasons for the same, including there must be overprice, or the appellant must have faced the underpricing of the shares. With regards to the same, Your Lordship, the pricing by the appellant of rupees 150 per share cannot be conclusively determined to be the right price. Your Lordship,
That's why they're asking you to appoint an independent valuer, right? So why are you averse to appointing an independent valuer?
Your Lordship, the Securities Commission did appointed an independent valuer in the present case, and as it has been stated in page 3, para 9 of the moot proposition, the independent valuer, the copy of the responses were also given to all the to the appellant in the present case. Further, Your Lordship, the evaluation reports were also set out in all, including all the considerations like the qualitative factors, the methodologies, the growth potentials. Your Lordships, on the various methodologies, the book value factor is also included, Your Lordship. Your Lordship, if I may summarize my second issue. Your Lordship, in the present case, the counsel for the respondent humbly submits that Aryan do not qualify as shareholders in the present case, as they have no shares to offer in the very first place, since the shares have been pledged on 3rd April 2019 to the account of the debenture trustee acting on behalf of the creditor. And secondly, robust commitment has been made by the Securities Commission to sell the shares to the third party through a share purchase agreement. Your Lordship, with regards to the same, the counsel humbly submits that the appeal is not maintainable under section 15Z of the Securities Commission Act 1992. If Your Lordships are convinced, may I seek the permission to call my co-counsel to deal with the rest of the issues? Much obliged, Your Lordship. It was an honor arguing before the Honorable Court.
May it please the Honorable Court. Good afternoon, Your Lordships. The Council shall be taking 28 minutes of the Court's time and consider issue 3 and 4 pertaining to the non-mandatory provision of providing valuation report for inspection at the time of open offer, and that the respondent has not failed to exercise its duties under sub-regulation 16 of regulation 8 and clause F of sub-regulation 1 of regulation 32 of the SAST regulations. The Council seeks permission to deal with the third issue. Much obliged, Your Lordship. It is humbly submitted, Your Lordship, that it is not mandatory to provide valuation report at the time of open offer, and the Council shall be establishing the same on the basis of 3 limbs. Proceeding with the first limb, Your Lordship, the Council humbly submits that there is no mandatory provision provided offer. The respondent has adhered to each and every aspect of the Securities Commission Act and the SAST regulation in the present case. It is further submitted, Your Lordship, that when there is no ambiguity related to the wordings used in a particular statute, then we should definitely adhere to the literal interpretation of the statute. The same proposition was upheld in the case of Raghunath Rai Bareja versus Punjab National Bank, wherein it was propounded that when words of the statute are unambiguous, the literal interpretation of the statute must be adhered to. Plain and unambiguous words in a statute must be given ordinary meaning and sense. It is therefore submitted that the respondent adhere to the literal interpretation of the SAST regulations and the Securities Commission Act, Your Lordship. Proceeding with the second limb, Your Lordship, it is humbly submitted that the justifications regarding the offer price has already been provided when the acquirer submitted the detailed public statement in the leading newspaper, Your Lordship. For this very fact, Your Lordship may refer to page 3, para 8, line 2 of the moot proposition. Your Lordship, the acquirer in the present case has issued the detailed public statement in a leading newspaper. Your Lordship, the Council humbly requests to refer to page 87 of the compendium for the respondent. Your Lordship, page 87 of the compendium is the format of the detailed public statement to the shareholders of the target company in terms of sub-regulation 2 of regulation 15 of the SAST regulation. If Your Lordship may refer to page 90 of the compendium, point 3, section 4, there is mentioned offer price. And Your Lordship, in that very particular point, it is stated that justifications of offer price in terms of the relevant provisions of the SAST regulation must be provided. So whatever the contents of the valuation report will contain and on what basis the valuation has been done, what parameters has been adhered to, and what parameters has been considered to come at this very particular offer price. So, Your Lordship, the contents of the valuation report is already mentioned in the detailed public statement as in accordance to, as the acquirer has issued the detailed public statement, point 3, section 4, that mentions the offer price and the justification to the same. Further, Your Lordship, moreover, the detailed public statement is being circulated in newspapers, Your Lordship, so that not only the shareholders per se, but the people of the entire country of Konark can speculate and inspect that whether the valuation which is being done is based on the correct parameters or not. It is proceeding with the last limb of the issue 3, Your Lordship. It is humbly submitted that whatever relevant documents which is required for inspection is already provided by the acquirer in the present case. For this very fact, Your Lordship, the Lordship may refer to page 4, para 11, last 3 lines of the moot proposition. The relevant document, which states that the relevant documents for the open offer were provided for inspection at the office of the manager, with the office of the manager. Further, Your Lordship, if you may refer to page 69 of the compendium, it is provided the format of the letter of offer. Your Lordship, if you may refer to page...
1 minute, please. Sorry to interrupt you. There is a
certainly, Your Lordship.
Request from the director that some dignitaries here have flights to catch, and this final is a little overdrawn and delayed. So could you please complete your submissions within, say, 12 or 13 minutes,
Certainly, Your Lordship.
and go as fast as you possible, compress it, and we will try to follow you.
Certainly, Your Lordship. Certainly.
And please don't take it otherwise.
Certainly, Your
Or a
Lordship.
breach of the principles of natural justice.
Certainly not, Your
Denial
Lordship.
of the opportunity to be heard.
Certainly not, Your Lordship. Your Lordship, if you may refer to page 81 of the compendium for the respondent, again, in the letter of offer, it says the offer price, the justification of the offer price is being stated. You may refer to the point 6.1 in that particular page 81, Your Lordship. Further, your lordship, in both of the formats, whether it is detailed public statement or the format of the letter of offer, the historical financials of the target company for the entire 3 financial year is already being stated. Your lordship, again, as it is being contended that in the present case regulation 8, clause E of sub-regulation 2 of regulation 8 is not adhered to, the counsel for the respondent humbly submits, the counsel for the respondent humbly prays the honorable justice to refer to page 79 of the compendium, again the format of the letter of offer, wherein in the present table, your lordship, book value per share is given. So the parameters are also fulfilled, your lordship, in the present case. It is therefore, summarizing my third issue, your lordship, it is therefore humbly submitted that it is not mandatory to provide valuation report, because whatever contents, whatever justifications in regard to that is already being provided when the acquirer issued the detailed public statement and the letter of open offer. The council now seeks permission to deal with the fourth issue, your lordship. Much obliged, your lordship. It is humbly submitted, your lordship, that the respondent has not failed to exercise its power under sub-regulation 16 of regulation 8 and clause F of sub-regulation 1 of regulation 32, and shall be establishing the same on 3 limbs. Proceeding with the first limb, your lordship, it is humbly submitted that the said regulation provides discretionary power to the respondent to act upon. There is no mandate on the respondent to adhere to the said regulations and appoint independent valuers in each and every case. And since in the present case, your lordship, all the regulations of the SCST has been fulfilled, therefore there is no need to appoint an independent valuer, your lordship. It is further submitted, your lordship, that until and unless some valid reasons are put forward by the appellant regarding the undervaluation of the shares, the respondent cannot assail the offer price, and the same proposition was upheld in the case of Reliance Media Works Financial Services Private Limited versus Securities and Exchange Board of India.
Why do you think, we are asking you, should or should not SEBI have given some reasons in the decision that it made, or in response to, in the letter that it wrote, or in response to that letter, why it was justifying a particular valuation?
Your lordship, it is a procedure that before issuing.
And why no further valuation is required?
Your lordship, because the Securities Commission in the present case is satisfied with the valuation which is being done by the acquirer, the creditor, and the manager.
How is the satisfaction expressed?
Your lordship, because as stated earlier, they have issued a detailed public statement and the letter of offer in which the justifications are being provided, and also the book value is also there, your lordship. Further, your lordship, the valuation is a question of fact. There are many considerations and many other parameters which is being considered while evaluating the shares of a particular company. May the council proceed, your lordship? Much obliged, your lordship. It is to be noted, your lordship, that the valuation cannot be assailed unless and until some fundamental errors or a patent mistake or a demonstratively wrong approach has been adopted while evaluating the shares. Proceeding with the second limb, your lordship, the council humbly submits that valuation is a question of fact. It is to be noted, your lordship, that even if correct parameters are applied, different valuers may arrive at different valuations. Valuation of the share is not a precise science, your lordship, and the same proposition was upheld in the case of GL Sultania and others versus Securities and Exchange Board of India. Proceeding with the last limb, your lordship, it is humbly submitted that the parameters let down under regulation 8 are by no means exhaustive. There are many other considerations which may be factored into any valuation process, and the valuation process is itself a commercial decision, your lordship. It is further submitted, your lordship, that none of the parameters is itself decisive.
All the factors have to be considered and valuation must be arrived accordingly. The same proposition was again upheld in the case of GL Sultania and others versus Securities and Exchange Board of India. It is therefore humbly submitted, Your Lordship, that the respondent has not failed to exercise its power under the SAST regulations. If Your Lordships are satisfied with the submission made by the counsel for the respondent seeks permission to proceed with the prayer. Much obliged, Your Lordship. In lights of the issues raised, arguments advanced, and authorities cited, the counsel for respondent humbly prays the Honorable Court to adjudge, hold, and declare that the communication dated 21st January from the respondent to the appellant is not a maintainable order and the appellant in the present case is not a shareholder. That it is not mandatory to provide valuation report for inspection at the time of open offer. That the respondent has not failed to exercise its duties and pass under the SAST regulation and pass any order that the Honorable Court may deem fit in the interest of equity, justice, and good conscience. It was an honor to argue before this court, Your Lordship. Thank you.
Yes. But, yes, 2 or 3 minutes only. Only on law, no facts anymore.
Indeed, Your
Decide
Lordship.
never on facts, only on law.
Your Lordship, firstly, Your Lordship, any action or inaction which an aggrieved party can seek an appeal under Section 15T has been read within this provision only, and the Council is relying on Nagarjuna Fertilizers versus SEBI of the 2015 judgment. Secondly, Your Lordship, the valuation is not a question of fact, Your Lordship. Everything is a question of fact. But the correct principle of valuation, especially of infrequently traded shares, is a question of law. And for the same, the Council has relied on this on the judgment of this honourable bench, this honourable court, in the case of Commissioner of Gift versus Executors of the Supreme, decided in this honourable Supreme Court. Secondly, Your Lordship, the Council, the learned respondents on the the Council for the respondent has submitted that right of redemption has been extinguished for the shareholders, which is not true, Your Lordship. Presently, because on the 10% shares, the shares has not been sold. There is no actual sale. And Section 177 of the Indian Contract Act provides that until and unless there is an actual sale upon invocation and reasonable notice, such sale cannot be deemed to be a sale, and therefore the right of redemption of the pledger cannot be extinguished, which is the present issue concern, Your Lordship, and submitted by the appellant. Your Lordship, secondly, Your Lordship, the detailed public announcement submitted as a sample is not to be considered in this regard, Your Lordship, although the framework provides that the valuation reports must be provided, but the moot proposition clearly states that no valuation report are provided for inspection to the manager, vested with the manager. Thirdly, lastly, Your Lordship, the respondent has cited the case of Reliance, wherein in the paragraph 32 itself it has been provided by this by the honourable tribunal that valuation report is mandatory and has been read under regulation 15.2 and regulation 15.3 of the SAST regulation for the shareholders to make an informed decision under the SAST regulation, Your Lordship. It is an established law that valuation report has to be mandatorily produced for the shareholders to make an informed decision. With that, the Council submits, lastly, that the sanctity of a statutory body cannot be merely reduced down to a middleman or a postman, Your Lordship. The SEBI is not here to forward the reply of a respondent without thinking, without having to consideration the consequence of such forwarding. And therefore, Your Lordship, the Council humbly submits that the appellant is a shareholder and has a locus standi, and the SEBI forwarding of this letters of the respondent by the SEBI is an order, which is an appealable order, and by the appealable order, the appellant has been agreed. That is my humble submission, Your Lordship. Thank you so much. It was an honor to plead before the bench.
The council seeks permission for the surrebuttals. The council seeks permission to oppose the dice for the surrebuttals. Certainly, Your Lordship. Much obliged, Your Lordship. Your Lordship, There is a robust commitment which has been made in the present case between the creditor and the acquirer, your lordship. And further, your lordship, valuation is a question of fact, and this is upheld in several cases, your lordship. Your lordship may refer to page, your lordship, in the case of Duncan's Industries Limited versus State of UP.
No new citation, you only deal with anything new CS said in reply.
Certainly, your lordship.
Or you can make a very short summary in 20-30 seconds.
Certainly, your lordship. Your lordship.
Facts. We have taken note of the submission that valuation can be different, it can be divergent, it can vary between.
Certainly, your lordship. Your lordship, and in accordance to sub-regulation 2 of regulation 15, the detailed public statement is already been issued by the acquirer. So there is no contention on valuation report, your lordship. Thank you.
Thank you.